Okay, Judge, can you hear us?
Yes.
All right, I'm going to move myself and then we'll both be in the screen. Okay.
All right. Let's be on the record in case number 2021 CR 60, captioned State of Kansas versus Joseph Marvellis Brown. Would the parties announce their appearances, please?
May it please the court, Christopher Schneider, Assistant District Attorney, appears on behalf of the state of Kansas.
Police Court Joseph Brown appears in person, and my counsel Zach Anthony via the Zoom platform.
All right, we are here set down for a sentencing today. We were all in court by Zoom back on April 16th, at which time the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted that, ordered a pre-sentence investigation and set sentencing. There was quite a bit of difficulty getting certified records from the state of Tennessee court. However, this morning, our probation officer was able to get that information and update the PSI. So a couple of things have been filed. There is the PSI that we all received this morning. We should have received and reviewed. There's also that followed that, a new and updated face sheet or page 1 of that PSI. So we're going to take that original PSI that we got this morning, remove the front page and replace it with the new front page that was received somewhat later.
Okay, I wasn't aware there was a second front page.
If you check your email, you'll see that Ms. Ariola sent shortly before the hearing an update with the probation order, if granted, and a new face sheet.
Okay.
Yeah.
Oh, I'm sorry, Judge, 'cause I was running around trying to get things ready for this hearing.
Sure.
So
It was just that it was signed. So
is that the only difference, is that it's signed?
in the sentencing date, I changed it from 21 to 23.
Yeah.
When I sent it in, when it was
From
submitted.
2021 to 2023?
No, from 2 days ago to today.
Oh, okay, got you. All right. Okay, fine.
All right. So I've reviewed this PSI. The critical findings are as follows. The sole count of conviction, well, I'm sorry, it's not the sole count of conviction. The primary count of conviction is one of violation of the Offender Registration Act. That is a severity level 6 non-person felony. The defendant's criminal history score was found to be that of C as in Charles. That would leave him with a presumption of prison and a presumed underlying range of 34, 36, or 38 months. If he has to do that time, he'll be eligible for up to 15% good time credit and subject to 24 months of post-release supervision. Special rule number 9 applies in that the crime was committed while on probation for another felony. If he's granted probation today, it would be to community corrections for a period of 24 months. Count 2 of conviction is again the violation of the Offender Registration Act. That's a severity level 6 non-person felony. For scoring purposes, defendant's criminal history score is considered to be I. That would leave him again with a presumption of prison and a presumed underlying range of 17, 18, or 19 months. The same 15% credit and 24 months of post-release supervision would apply. I'll ask you first, Mr. Schneider. I know these have all come in late. Have you had an opportunity to go over the PSI? Do you have any additions, corrections, or challenges to the findings?
Judge, I had the opportunity to look at it as best as I could. It does need to be amended. There is a special rule 46 applies to both counts, which is the
Right.
rule which makes offender registration offenses presumptive prison.
Correct. Okay. Yeah. So there is also a special rule number. It's 46, did you say?
Yes, Your Honor.
All right. which is the violation of the Offender Registration Act. Ms. Ariola, I assume you agree with that?
Yes, I
right.
will amend that and get it out
Thank you.
to you guys right now.
All right. All right. And I do think that that is appropriate, and I will amend the PSI to reflect that for both counts. With that change, Mr. Anthony, I would ask you, do you have any additions, corrections, or challenges to the findings?
I do not, Judge, and we don't contest the applicability of Rule 46, so we acknowledge that an amended PSI would be accurate if it reflected that. We have always expected Mr. Brown to be a criminal history score C. Plea negotiations and my own interactions with Mr. Brown have all led me to believe that he would be a C based on that single old robbery and then a series of things that came out of Tennessee, any number of which could give him that score. So we have always anticipated that. We've reviewed it here today in my office. We do not challenge the criminal history score of C or the crimes to give rise to that score.
All right. And I would assume, I know it came in at the last minute, but I think we need to make a record. You've had an opportunity to review the new convictions added to that. It looks like they were all misdemeanors, but you've had ample opportunity to review those and you don't have any objection to them being included as well. Is that correct?
Correct on both points, Judge. We have reviewed it. Obviously, we had only a few seconds to review it. However, Mr. Brown acknowledges that those crimes were his and they don't affect his criminal history score. So we don't challenge any of those as being included.
All right. There being no challenges to the findings of the PSI with the amendment to the special rule number 46 for both counts, I will adopt the findings of the PSI for today's hearing. Mr. Anthony, you have provided to the court, and I assume counsel, a copy of your unfiled motion for departure. Obviously, without the PSI early on, it would have been difficult for you to file that. So I'm assuming you're going to file that.
It has been
hearing.
It has been filed, Judge.
It has. Okay.
I did have an opportunity to get it on file with about a minute's notice. So we heard it at 9:59, Judge.
All right. So
And
with that,
I received
we heard on
notification
that
from
motion today.
Flex.
With that, Mr. Anthony, would you like to be heard on your motion today?
Judge, I won't recount everything that I've said in that matter. I would just say, Mr. Brown has, in my interactions with him, has been respectful and has taken care of business when he was called upon to do so. He's on probation. I don't know how much longer he's on probation for. Apparently, he's just finished probation in Missouri, June 1st. So he successfully completed that matter, which shows the court that he can take care of his business when he needs to. I have physically met with Mr. Brown at his home, and I can tell you with firsthand experience that he is a very busy man taking care of a lot of young children. So Mr. Brown's got a lot of reasons to stay out of trouble. He's got a lot of reasons to stay in compliance with the registration requirements, and I think he's a good candidate for probation. With all that being said, Judge, I would ask that you follow the plea agreement and give him that opportunity.
All right. Mr. Schneider, I would hear any of your comments as to the defendant's motion for departure and anything else touching upon sentencing.
Judge, I would ask the court to follow the plea agreement in this case. That would include granting the motion for dispositional departure. We made that agreement basically for the reasons that Mr. Anthony just stated to the court a few moments ago. But we believe that the position the defendant's in at this point in his life, that it's in his best interest, it's in the community's best interest, that the court depart and that he be given the opportunity to get his life together. I think he understands that there are registration requirements involved as long as he's in the state of Kansas, and hopefully this will be the final hearing we have to have on this matter, and we won't be back for anything else.
All right, thank you. Mr. Anthony, I've heard your motion today. Anything else you want to say regarding sentencing?
No, Your Honor.
All right, Mr. Brown, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today. I can't, he can't be heard.
I have, I have got custody of my kids and everything. So, I'm trying to do the best for them and stay away from the corrections because I'm all they have, They don't have any mother or anything, it's just me. So, what being granted probation, I'm gonna do everything I can to complete it like I completed the other one. I'm not trying to go to jail. Period. I mean,
All
so
right, well, I'm glad to hear that. And it's certainly within your power. And the important thing is going to be, this is not a registration offense, but you need to keep yourself aware of your registration requirements in your other cases and make sure you meet those, because it is, you're looking at 50 some odd months in this case. And if you caught another case for not registering, it would probably have to go consecutive to that. So look, I want you home. I want you with those kids. You need to make sure that you're taking care of the business so you can be there. Okay. All right. Mr. Anthony, any legal reason why I should not now proceed to sentencing?
No, Your Honor.
All right. Well, I'm going to follow the plea agreement. I'm going to grant the defendant's motion for a downward dispositional departure. I will adopt as substantial and compelling reasons for that departure those set out in the defendant's motion and mentioned by defense counsel today. Therefore, for count 1, violation of Offender Registration Act, a severity level 6 non-person felony with a criminal history score of C, Mr. Brown will be sentenced to the standard range of 36 months in prison. If he has to do that time, he'll be eligible for up to 15% good time credit and subject to 24 months of post-release supervision. As to count 2, also the violation of Offender Registration Act, a severity level 6 non-person felony with a criminal history score of I, he will be sentenced to the standard range of 18 months. The same 15% good time credit and 24 months apply. That count is ordered to run consecutively with count 1. That is pursuant to the plea agreement and at the discretion of the court today. Mr. Brown's application for probation is considered and it is granted to community corrections for a period of 24 months, along with all of the other standard and normal conditions of probation. One of the conditions of probation for Mr. Brown will be that he abide by the registration requirements from his other cases. And that is not only ordered in those cases, but as a condition of probation in this case. Mr. Brown, I know you're taking care of your kids, like you said. How do you do that? Are you employed?
yes, I am. Yes, sir.
All right. What do you do?
I work at a frozen food warehouse.
All right. About how much do you make a month, do you think?
From 12 to 1,300.
12 to 1,300. And how many kids are you taking care of?
2.
2. All right. Mom's not in the picture. She doesn't contribute financially or in any other way. Is that correct?
She left them in DCF custody and went back to Memphis.
All right. Well, I am going to, given that, let's see, here's what I'm going to do. I'm going to assess court costs and supervision fee. I'm going to waive all of Mr. Anthony's fee, and I'm also going to waive the KBI database fee. Is this Mr. Brown's first Kansas felony conviction?
Yes, Your
Please,
Honor.
so, Judge.
Yeah. So he still has to submit the DNA sample, but I'm going to waive the fee as a manifest hardship to the defendant. So Mr. Brown, total here, you're gonna be looking at about just over $300 during your 24 months of probation. If I ordered you to pay $25 a month towards those costs and fees, do you think that's something you could do?
Yes, sir.
All right. And that should get him paid off well before he's done with probation here. So that's going to be the court order, $25 a month. Again, assessing court costs and supervision fee, waiving bids fee, waiving attorney fee, and waiving KBI database fee. All right. So a few things I need to advise you of, Mr. Brown. As a convicted felon, it's prohibited for you to own or possess a firearm, and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. You have 14 days from today to appeal anything you don't like about your sentence, and you may be able to seek expungement of this conviction after a period of time following successful completion of probation. Your registration requirements from the other cases, as I have said before, remain, and you need to make sure that you're aware of those and that you follow those. Do you understand all these things I've just advised you of?
Yes, sir.
All right. Mr. Schneider, what do we know about jail time credit?
Judge, he has time from February 4th to March 17th of this year.
All right. So roughly 45 days, somewhere in there. Someone will have to calculate that better than
28,
I.
13, 41.
All right. Does that sound right to you, Mr. Anthony?
Yes, Judge.
He'll be given credit for that time. All right. Given all of that, Mr. Schneider, anything I failed to cover today?
Judge, the PSI reflects that he was on parole out of Shelby, out of Tennessee, excuse me, the state of Tennessee. Do the sentences of this case run concurrent or consecutive to that?
Assuming that they're still there, the law does not require me to run them consecutively since it's an out-of-state conviction, and therefore I will order that they run, that this sentence run concurrently to that sentence. All right. Other things for our record today, Mr. Anthony?
Nothing from us, Judge.
All right. Megan, you think I've covered everything here? Anything I've forgotten?
Yes, I believe you've covered everything. The bids fee and attorney fees.
Yeah, I waived those.
Okay, that's what I thought. Nope.
Right.
I
Megan,
don't
what's the phone number that I give him to report, or do I send him to the third floor right now?
Hold on, let me stop our live stream before we start giving out phone numbers.